firms that are starting up and trying to do some kind of program or project using this technology. And so today's presentation, I'm just going to put a YouTube video to start, and then I'll get the slides going properly. But today's presentation, we're going to look at how the SEC regulates the art market. And we'll start off with a little video. Who in here is familiar with DJ Pepe? Okay, a couple people, great. Well, DJ Pepe, just for a little background, is a counterparty trading card, and it's a frog that's a DJ, and behind, like, if you own DJ Pepe, you get access to an exclusive playlist. And some of what we talk about in this art community is whether or not these trading cards are going to be considered securities by the SEC. And we don't want that to be the end outcome here. So this video kind of was made to summarize a little bit of it. So we'll start off just by watching this. I hope the sound will work. Okay, good.
Stop right there, DJ Pepe. This is the SEC. You've got to come with us. You're an unregistered security.
Well, hello, ladies. The SEC shirt is beautiful. Damn, y'all fine. Y'all tripping if you think I'm a security. I'm a frog. I'm out here frog scratching through the streets of Miami, enjoying our basketball.
Frog scratching or not, you still meet the definition of an investment contract based on the Howey Test.
When your manager sold you, it was 1, an investment of money, 2, into a common enterprise, 3, with an expectation of profit, and 4, based on the efforts of the third party.
Now stop right there, pretty ladies. I was created through some magic sorcery on the counterparty chain. I live on the 434,102nd block of the Bitcoin blockchain, created on October 16th, 2016. I am a good. The music linked to my token is something people consume. I give the service of providing education and laughter to all my counterparty peeps and frogs. You could say I'm an idea expressed through code.
Well, we've been analyzing all of these crypto cases under the Howey Test analysis.
Girl, that's the old law, 1946. Check the newer cases. In 1975, Honorable Justice Powell of the Supreme Court wrote a beautiful opinion. The case was called United House Foundation versus Forman. It said, when a purchaser is motivated by a desire to use or consume the item purchased, the securities law does not apply. Y'all can use and consume me all night long, though.
Well, in the same case, the Supreme Court also said the touchstone for determining the security is the presence of an investment in a common venture premised on a reasonable expectation of profits from the entrepreneurial or managerial efforts of others.
DJ Pepe, we go way back. Give me a card because he likes my show. Bitcoin card talk.
Hey, Dropbuster here. I bought DJ Pepe, so I can hear I wear Gucci. Great relief.
I bought 5 DJ Pepe cards, and I did not buy them to make money of it or resell them right away. And for me, it's very interesting. It's a building an art collection, and building a digital art collection, showing it to friends, to institutions, and really building the awareness on the new type of art, which is the digital art on the blockchain.
I got DJ Pepe, and I love art and music.
Well, when looking at the economic frugalities of the transaction, analyzing substance over form, it does not appear that the DJ Pepe token is an investment contract or any other instrument commonly referred to as a security.
I can use my turntables as an instrument.
Well, we're going to have to consult with our boss.
Oh, you mean my boy Clay Jayton? He's from Virginia like my manager. Yeah, Clay was a dope soccer player for Lafayette College back in the day. We're pretty tight. Ladies, make sure to tell him you don't need to even bother with that Howey case. I'm a consumable good, first and foremost. But if he wants to go down the investment contract rabbit hole, most of my 169 tokens were given away long before that DAO event where Clay raised the securities question for the first time. I heard that Marco Santori, Fraud God Lawyer, on Laura Shin's Unchained podcast a few weeks back on November 6th. Marco said, without an investment of money, there is no investment contract. Anyone talking about these free stock cases is missing the point that a stock is an enumerated security under Section 2A36 of the 1940 Act, which is almost identical to the definition of a security in the 1933 and 1934 Acts.
Yeah, DJ Pepe, we get it.
Okay. So that's kind of a summary of it, and oh shoot. So, one moment. I just need to get it to fit. Sorry, I'm used to the Apple computers, and I don't know how to make this one go full screen. There we go. Thank you. All right. So frogs. Like how did we get here to be talking about frogs on the blockchain? And if you look back into ancient times, frogs were considered to be an agent of chaos or something that brings change, and they were often depicted in ancient European or ancient Egyptian art sculptures with the word kuk. K-U-K, which has kind of morphed into what now online people call kek, or it's, I think what they say, it brings chaos. And these rare pepes were kind of sprung up as a joke, or they were commenting on the ICO culture that was taking place within this blockchain space, and they started selling, and they really took off. Like it was a really interesting thing to watch, and I missed most of it. I only learned about it towards the end. But if you look at some of the frogs that are designed, it's really good artwork, I think, and so then it presents a burning question for crypto as how is this stuff to be regulated? So, we've seen an explosion around crypto art that all kind of piggybacked off the rare Pepe trading, but are these assets? Are they securities? Are they trading cards? Are they in-game items? If you look at the Fortnite skins, like those people are spending quite a lot of money on those skins, and it's different than digital money being spent on it, but it doesn't require all the regulatory oversight that we're seeing attached to the conversation around crypto art. And the only real difference is that this crypto art is being paid for with cryptocurrency, which has a lot of different meanings. So this is just kind of an overview of all the various art projects that have come out of the rare Pepe trading. As you can see, there's a lot of them, and they focus on several different things. Some look at title, provenance, authenticity. There's insurance, there's lending, securing IP royalties, and issuing tokens. And it's just a huge booming industry has kind of spun up out of these rare Pepe tradings. And one of my favorite ones is the game called bitcoins.com, and we have its creator, Dan Anderson, sitting in the room with us. And and it's the way, how many farmers are in the room? Quite a few, yeah. And you've probably seen the table out there, but this is, I think, a fairly novel application of cryptocurrency because you own crops that are a counterparty asset, and depending how many crops you own, you get harvest of corn, and corn is another cryptocurrency asset on the counterparty blockchain. And then all the different farmers make trading cards or cards that are issued, and they're sold for corn. And it sounds really funny, like just to explain it, but it's a lot of fun. And if we were to regulate all of this as a security, then none of it could happen because every movement of each card would be required to be registered with the SEC and all the KYC information done on it. And it would just really eliminate the ability for this game to really exist. And then we have the DJ Pepe token that we had seen him in the video earlier, but DJ Pepe, he has his own Twitter account, and he does provide a lot of information and education, I believe, to the overall space. And you can't just look at him. He's not the same as a Bitcoin. He's got what I think is a consumable nature to him, or he offers a service. It's not just a financial transaction here, because if you own him, you can also hear all these songs that are attached to an exclusive playlist that show up behind the card if you're playing with it in your counterparty wallet. This is just a meme we made. There was all kinds of people on Twitter saying that Wyoming doesn't exist. And so DJ Pepe made this saying, yes, it does exist, proof of existence. But and then there's also Cryptograffiti. He just recently did a art piece where he used the Lightning Network. So he made this black swan as kind of a commentary on the various economic events that we call black swan events. And he made it all out of a dollar bill, and he sold it using an auction, a Lightning Network auction, and it's actually the cheapest piece of art that's ever been made. It was sold, they did it to explore how micropayments can work, and it sold for I think it was like 10 zeros, 37. So it was a very, very cheap artwork, but just looking at how we're able to explore these technologies. And then there's a company called superrare.co, and they're issuing, they basically have an art gallery using the Ethereum blockchain where each token or each art piece is attached to a token, so people can go on and buy it and pay for it with Ethereum, and they get this, they're just building their own digital art collection. So then brings us to the question, who regulates crypto art? And these are the 4 main regulators at the bottom. And I always love this meme that's at the top with the guy. It was when China said they were banning Bitcoin, and this meme started circulating of, that little fence. It's like, I just thought it was so funny because you can go around that fence so easily. And that seems to be how the nature of cryptocurrency works. The government will come in with some kind of regulation that may or may not make sense for the technology, and then the technologists can quickly and easily kind of circumvent the regulation as they build the technology. So the main 4 that are regulating in America, the first, or the one we're focusing on the most today, is the SEC. They're a federal agency, and they're charged with the mission of protecting investors, maintaining fair and secure markets, and facilitating capital formation. And they were created by Congress in 1934. And then in 1974, the CFTC was created, the Commodities and Futures Trading Commission, and they regulate futures and options markets, and they've claimed jurisdiction over Bitcoin, and a New York case agreed with that. So Bitcoin at the moment is the only thing that the CFTC has formally adopted regulation of, and the SEC has said that they regulate anything that would be considered an investment contract, which we're going to get into more as we go on. And then there's FinCEN, and they regulate, they're the Financial Crimes Enforcement Network, and they collect and analyze all the data about the financial transactions. They're looking to combat money laundering and terrorist financing. And you have to register with them anytime that you're moving in the currency at a federal level, and then there's also state governing bodies that regulate money transmission. So FinCEN will look at 3 different types of people. You're either a user, an exchanger, or an administrator. So if you're administering a currency, so most companies that are doing ICOs, they're administrating a new currency on top of another blockchain, they would be considered an administrator, and they would be required to register with FinCEN at the minimum, probably a lot of different states too. But when you register with FinCEN, you agree to collect certain information and pass it along, and you are required to do so, and if you don't, it can be a criminal penalty. So it's I think something that the ICO industry, a lot of people didn't register with FinCEN, as well as not registering with the SEC. And then we have the IRS that taxes property, and So there was one tweet that was put out by an attorney and a publisher for the block. His name's Larry Cermak. And it went through all the different government spending on blockchain technology. And we see the IRS actually has the biggest piece of the pie here at 38%. And I would have thought the SEC and CFTC, that's where it seems like all the action was in 2018, but the IRS spent more money on it. So we might see more coming from them in the next year or two. And then we had the ICO Craze. It's okay. Well, I was gonna do a little prize. So, who knows how much money was raised through ICOs until the end of 2017? Okay, we'll take 4 guesses. Okay. 30 billion? Okay. Well, I'll show you the video. But according to this, it was 6.8 billion. 10 billion, yep. And the prize is a Bitcoin corn tank clan card. If you'd like to join our farming card, so we can show you how to use it after. Okay. So yeah, this video here kind of depicts it. Anytime now, computer? I haven't used a PC in almost probably over a decade, so I'm not great with, I don't even know where you connect to. Oh, yeah, okay, here we go. Yeah, this looks like it's gonna work. Needs like a Chariots of Fire soundtrack. Yeah. Here, it's gonna start to get big. And there we go, yeah, so that was a pretty nice depiction of what happened during that ICO craze. And so maybe we can get the audience participation here. What are some common criticisms of ICOs? They've been linked kind of to the people that were the snake oil salesmen. Do we have anyone that can kind of elaborate on some criticisms of them? Sure. Mm-hmm. Yeah. Yeah, that kind of sums it up.
Using Hollywood actors as advisors.
Yeah. 2 of them did, yeah. Well, it was, I think, DJ Khaled and Mayweather, yeah. So, yeah, some of the biggest things, I think, first of all, it misaligns the company incentives, because typically a company that's going to raise money through venture capital has to come up with a really detailed and solid business plan and show, that they've got something of substance for a venture capitalist to actually invest in it. And then they have to use that investment wisely and grow and become, a better company, a bigger company, get to a revenue stage, and then they can get another inflection of money from venture capitalists. Whereas this model brought in all the money up front without any building of the company. And that's not to paint everything with the same brush here, but it happened a lot. And then nothing got built and all the money went in, or it's stuck in various regulatory purgatory situations too, and there's no investor protection. If you're going to raise money through the SEC method, there's always a bad actor check, and it seems like we got a lot of bad actors attracted to this space who didn't have to go through that bad actor check. And also, finally, private key management is very difficult, as we're seeing from the Canadian exchange Quadra CX, or just anyone raising money. There's a lot to handle being your own bank and securing other people's funds. So I think the DAO hack was kind of the first thing that brought the SEC's attention, and they tried to say they were a decentralized autonomous organization, and they had a smart contract with voting rights, and they raised, it was actually, I think, $168 million, and then that contract was hacked, and they decided, instead of to lose everyone's money, they rolled the blockchain back one and forked it. And that, I think, there was a big debate of whether that was the right thing to do or not in this situation. And I think it pointed out that it wasn't really a decentralized system if they have the ability to decide to roll it back. But after that, the SEC put out a big notice saying that at least that one in particular, that ICO, was the sale of a security using the investment contract definition. So if we take a look back, the SEC started regulating markets in 1933, and it was kind of something that was structured after the Great Depression. And before the SEC was in charge of the federal securities sales, it was all done by the state blue sky laws. And the blue sky laws had various, it was a merit-based review, so you had to tick off several boxes. And if you met those qualifications that your state put in place, then you could sell your security. If you couldn't, you just had to go away. Like, you had to come back with a product that met the boxes. Like, there was no wiggle room. Where the SEC, their main thing that they said is, as long as you disclose everything to the investors, then you can sell it. They just need to be able to make an informed decision about the risk that they're taking. So that was the big difference with the SEC oversight, and I think that's what their concern is with the ICOs that had happened, was there's no disclosure coming to the investors. A lot of people were buying these ICOs thinking they were very similar to stocks, and then realizing, oh goodness, this gives me nothing. Like, this token doesn't give me a vote in the company. It doesn't give me any ownership function. It essentially, so I think that was the big problem with the ICOs, was this lack of disclosure, so people didn't know what they were buying. And shortly after they were found in 33, 34, came the 1946 Howey Test, which was used to determine if something was an investment contract or not. So the SEC's 1933 Act definition of what is a security, it includes a stock, a bond. There's about 19 different things that are enumerated in the Act. One of those things is an investment contract, and it's kind of the catch-all for anything that doesn't fit the definition of the enumerated securities, like stocks and bonds and certain oil contracts and things. So they said, so the facts of the case was, there was a farmer in Florida. He sold plots of his land to a group of different people. They gave him money. He used their money and harvested these oranges. And then he'd sell the oranges, hopefully for a profit, give the people back more money than they gave him. And the SEC looked at it and said, primarily, they're giving him money, they're trusting him, they're relying on him, and they have no ability to make their own money grow. They don't have They have to completely trust him. It's his work that's going to grow that money, and that's kind of the line that creates when something is a security or not. So, the four prongs, if it's an investment of money, a lot of the crypto companies, after the DAO notice came out, said, well, we're investing Ethereum. That's not money. And since this case is so old, if you look at it in Westlaw, it has been cited to over 1,900 different times. So it has gone all through our case law system, and the prongs have expanded to encapsulate almost anything under the sun. So money can be Ethereum, it can be time, it can be any kind of expenditure of value. So is what the SEC has said over the years. So people saying, oh, we don't meet that test because we're only investing Ethereum, that argument doesn't hold any weight. And then into a common enterprise, if a company is saying that they're a decentralized autonomous organization, that also doesn't hold any weight when there's a central player that has the decision to turn the blockchain, roll it back or whatever. That's not a autonomous or decentralized organization. It's very nuanced because the SEC has since come out and said Ethereum actually is sufficiently decentralized, not looking at the initial sale. But when they're looking at the factors, the common enterprise test, it's pretty broad too. And the DAO model, it just defaults under American law to be a partnership. So anyone in there is a partner with each other. If you don't register as an LLC or a corporation, you don't have the corporate protections of being having a shield for limited liability. So you have liability for everything that your partners do. So it's a really kind of dangerous legal or of made-up structure that doesn't fit within the laws that we have. I like the idea of it, but this is just, it wouldn't hold in court, and the SEC kind of said so too. And then, now when you get into international players too, it might change the game a little too. But yeah, and then with the expectation of profits, that's a pretty subjective one, but as we see with the ICOs, there was some real pump and dump behavior out there with people saying that you're going to have these exceptionally high gains. So it's easy to see the expectation of profits and then being derived from someone else's work. That's actually one of the beauties of Bitcoin, the Bitcoin game structure, is it's derived from a community of people's work. Like Dan will take votes or take the ideas of other people and merge it into the game. Whereas a lot of these companies do it so no one that owns the token has any say in how the company is going to develop. So that's kind of the difference of whether it's solely derived from someone else's work. And then we saw some enforcement. So the Munchee one was the first one, and this was just a little one. It was a baby ICO, kind of 60 grand raised from 40 different people. And so they gave the money back, and the SEC, they had written in their white paper that they passed the Howey Test, but they didn't give any explanation of how or why they thought that. And I think it was one of those things, oh, people invest Ethereum, so it's not money. But they also said that they would have 199% return, which we know now is a pretty big no-no to say. And then there was the Centra Tech one. That was a real case of outright fraud, and the Department of Justice had to get involved and got one of the founders at the airport as he was about to flee the country. But they raised $32 million, and they raised it on a pack of lies saying that they had partnership with Bancorp and Visa and MasterCard, that basically you would use this Centra card, and they had Floyd Mayweather and DJ Khaled going around, oh, here, get the Centra card, and you're going to be able to use this card at any store like you would a Visa or a MasterCard, but it's going to access your Centra tokens. And they never made the tokens, and they never had those partnerships. And they had completely made-up advisory board, things like that. So it was, it just became this weird culture of sprinkle a little blockchain on it and it will solve everything. And it kind of, everyone was thinking blockchain would work for every problem under the sun. And I'm not saying that it might not eventually be a way to solve a lot of problems or create efficiencies, but at the time in 2017, it just didn't work. And we saw a lot of ICOs coming out of, I think it was out of India, that had photos of Ryan Gosling in different, like he'd have glasses on, or he'd be a little different, and they'd have a different name under him. But they knew that Americans like Ryan Gosling, so they say, oh, this is our advisor with some different name, but the picture will appeal to us, and we'll buy their ICO because of it. Or there was people said they were going to mine on the moon and give tokens of it. There was bananas going on the blockchain. Like, it just became a really exuberant thing where almost anyone with any kind of idea could make money through an ICO. And then we got, there were a lot of state, federal actions, but we also got state actions coming saying that these were violations of the state securities laws. We had over 200 investigations and 50 enforcement actions. And then at the federal level, this is kind of a summary of the fines. So the disgorgement, like having to pay back your ill-gotten gains, and then civil penalties that went right to the SEC. And I don't think we're done yet. There's a 5-year tail on these, so the SEC has quite a bit of time to go back and find any other ones. And then we got the comments how this applies to art is just like these bad actors, I guess, kind of came out and made these ICOs for everything, and the SEC had to react because there was an abundance of fraud, but then it created an environment where it's like almost everything, even the companies that are using this technology for innovative ways, is getting hampered, or there's a fear that the SEC is going to regulate on that. And then the director, Henman, came out in the summer of 2017 and said, if you're sufficiently decentralized, you may not be a security anymore, in terms of Ethereum anyway. And so that would open up, if Ethereum isn't a security, is kind of funny because they were sold as an ICO, and they meet all those definitions if you look at their initial sale. But now, 3 years after that initial sale, there's quite a network effect with Ethereum. And if the SEC were to say that was an ICO and a legal sale of securities, it would really it would have really probably crippled a lot of work that was being developed. And I think there was a lot of people on the Ethereum side, like Consensus, going to, and all the blockchain alliance places, wanting to see this technology succeed, so they were lobbying to the SEC, saying we're not a security, don't paint us with the same brush. And the SEC listened, made this speech saying if you meet certain decentralization qualifications, if you're sufficiently decentralized, you're not a security. And the CFTC, who we've talked about earlier, they have jurisdiction over Bitcoin. They have not claimed jurisdiction over Ethereum yet. They're open for comments, and actually the comments have been open for 60 days since December 11th, where they're trying to assess, is Ethereum like Bitcoin? Is it a commodity that they should regulate? And if they regulate it, it means it can be traded in hedge funds and not considered an investment company. So anything that was sold illegally as a security but not registered, an investment advisor for typical people, not the regular crypto folk, but the mom and pops out there, an investment advisor can't add that to the portfolio because there's a lot of compliance problems. But if it's considered a commodity, it can be traded in hedge funds, and in hedge funds that aren't registered with the SEC. So I think that's why. And then if they were to have futures on these things, I think that if the CFTC claims ownership, it can do the futures contracts like they're doing in Bitcoin. But when you do that, the hedge fund does have to register with the CFTC. But it'll open up some other opportunities, and I think the CFTC wants to be careful and make sure that it's the right decision to move it there. So they've had the comments open for 60 days. And then a lot of questions came around airdrops. So people were worried, well, if these things are securities, or maybe if we sell it, if we're using the investment contract, if we sell it for free, then it can't be a security, right? And then all kinds of attorneys jumped all over that and said, no, if it's if it's a security, there's all these free stock cases that said even if you give the stocks away for free, those are still securities. So people were saying, oh, you can't even airdrop this stuff. But in Marco Santori, who I think is, in my opinion, one of the who I think is one of the best attorneys in the space, he talked about the airdrop issue on Laura Shin's podcast in November, and I think he did a great job on it. So I'm just going to play, it's like a minute and a half of him talking. I got to find the spot.
And distributing to tens of thousands of people that keep going. And that's...
So the swift and obvious answer is that, well, it depends on what you're airdropping, right? If you're giving something away for free, well, that can't be a securities offering. But the law has said, very rare you're ever really doing anything for free, are you? You're always trying to do something for yourself. And so there's a whole line of stock giveaway cases where companies have given away their stock for free and taken the position that this can't possibly be a securities offering. Where are any of the investor-based risks if the investor hasn't given us any money? Well, the thing is, stock is an enumerated security in the Securities Act. If you're giving it away, you're getting something in return, whether it's goodwill, more users, increased metrics, basically anything, even if the user isn't directly paying you. Well, that passes the standard. The standard for a securities offering is whether it was, quote, for value. It's a very low standard. Of course you got some value out of it, even if it's self-aggrandizement. There's some value that you got from it. So that the actual offering of a security via an airdrop, well, that would just be a securities offering. It's hard to imagine how you could avoid that. But if the thing you're giving away is not a security, then, well, it can't be a securities offering. And that's not a controversial position. This is sort of black letter law. And remember, in order for a token, at least most of these utility tokens, to be considered securities, they have to be there has to be some investment of money. There has to be some payment to the involved in the transaction scheme, or at least some what's called capital put at risk. For the legal evils out there, it's not the risk capital test. It's something else. The case law is pretty uniform. That the person getting the thing, in order for the thing to be an investment contract and therefore security, well, has to pay something. They have to put their capital at risk.
But Marco, so I looked up those cases.
Okay, so that's kind of explains that part. And then, oh, yes, sir? Yeah, I guess you're right in terms of the tax. So you would have a zero cost basis on the securities or the utility tokens that were given to you, but then you're saying the tax that you'd have to pay would be what the SEC would say was your investment of money.
Yeah, or there's just a line. I mean, your cost basis is zero before the transfer, and
Mm-hmm.
it's $10,000 in order to pay tax on the $10,000, and my cost basis becomes $10,000. So there's kind of like a record keeping. I mean, that's the standard that I think would apply. Have you seen that in the space or no?
I haven't, and we've only seen one enforcement action against an airdrop to have any guidance from the SEC. That was the Tomahawk case, and in that one, the guy was saying that the airdropped tokens would be convertible into penny stocks. So it was in that actual stock zone, I'd say. But I guess to be determined.
I guess if you were gifted the rules for the KYC or the accreditation, all that stuff, you could gift it to the person if they met the standard if you did that.
And then, so if you were to follow, like if you weren't wanting to sell them as an airdrop and you want to sell them as a security and just not have any problems with the SEC, not have any of this challenges, then you'd have to do it as a Reg D token. And with that, you end up in a mess because you have to sell it only to accredited investors, which eliminates a giant pool of people that are interested in cryptocurrencies. To be an accredited investor, you have to be a millionaire or a net worth of over $1 million or 200 grand annual income. And then you also have to lock the tokens up for a year. So it really makes it difficult to use these in a meaningful way. So then there's the case United House Foundation versus Forman, and this was looking at it was a real estate that some people were saying was an actual sale, an unregistered sale of security, and other people were saying, well, no, this is a house, it's a consumable good. And the outcome of that case was, this quote I love, when a purchaser is motivated by a desire to use or consume the item purchased, the securities laws do not apply. So when you're thinking about crypto art, if you're, taking that line from the case, from the Supreme Court, if you're motivated by this desire to use or consume the artwork, the securities laws shouldn't apply to that thing. And if you were thinking about it like a trading card or something that was actually physical, that the securities laws certainly wouldn't apply to that. So, they laid out kind of a way to analyze when something is a security or not, different than the Howey Test, but they're saying a big thing is receiving dividends contingent upon the apportionment of profits. And so they're saying if something's negotiable, subject to pledge or hypothecation, confers voting rights, and that it has the possibility of appreciating in value, then those are kind of the guidelines. And that's what Europe uses too, is the dividend test. If it pays dividends, it's a security. But, it brings us to the question, what is a consumable good? And there's a lot of definitions for it, actually. So the Webster's Dictionary just says, it's something that satisfies a human want. It's pretty broad. Then other cases have said it's something like you buy it, you have to be able to use it, like a groceries or a cleaning supply. And then the UCC came up with a definition of it. The UCC is the Uniform Commercial Code, and it governs contract law for goods and it requires that something's movable and at the time of the sale and at the time of the identification. And so then there was a lot of case law that looked at whether or not electricity should be considered a consumable good under the Uniform Commercial Code. And what they said with that, it was a lot of cases that went back and forth. The 10th Circuit in 2017 said that electrical energy meets the criteria for being goods because it's a thing that exists. So if you think about it as a rare Pepe token, this is a thing that exists. It can be identified. You can identify it on the blockchain. It's capable of being sold. And by the daily activity of turning on a light switch, we know that energy moves, because that's one of the other criteria. It has to be movable. Well, by using X-Chain or some kind of block explorer, we know that art tokens move. So I think it can fit that definition. Then there was another case in 2009, the Pilgrim's Pride. They were saying that electricity is not a UCC good because they think that the drafters of the UCC intended that it would be something that could be packaged or handled. So it's not something that you can't see or touch. So then so now 22 states consider electricity to be a tangible personal property, which is kind of interesting because, like, when I think tangible, I don't think electricity. I think like my phone is my phone's tangible. But then they came up with a definition of it saying that if it's something that can be seen, weighed, measured, felt, or touched, or any other manner perceptible to the senses. So if I'm looking at my computer screen at a digital art, that's seen, I see it, I perceive it, so maybe that fits the definition of a good. And then pre-written computer software went through this same analogy. Starting in 1985 was the first case law that tried to put computer software into the category of being a tangible good. And now it's well-settled law in 2015 that, yes, computer software is a tangible good, and it is under the UCC definition. So I don't know where that will take us over the long run, but it's certainly an argument that not all of these things are securities, and if they're not securities, if they're consumable goods, where would they fall? And I think that we, over time could get it into that UCC definition. Now, Wyoming is the only state that has already kind of done this. They did it last year with their House Bill 70. They said that utility tokens are seen as property. It excludes developers or sellers from their securities laws. Now, this doesn't hold up because the SEC governs, the federal law trumps state law in these cases. So if you were to make a utility token in Wyoming and not use the interstate commerce, which includes email or a telephone call or a road, then you'd be safe there. But otherwise, if the SEC thinks it can attach, it can. So it's, we got a long way to go with the way that this law can develop, and right now there's a lot of uncertainty with it, but the Brooklyn Project is a group in New York. They came up with a consumer token model that I think it makes some good sense. They're saying instead of having it be an accredited investor test, have it be the person that buys the token has to take a specific test that asks them various questions where they prove they understand the risks. And it can't be sold with any kind of speculation on the price, but it can actually be sold to investors, but there can't be pre-sale. Everyone has to be allowed to register with the network, and then they have to prove that they used it in some kind of useful way, that they didn't just buy it on an exchange and then sell it hoping for a profit, that they actually used it in whatever network capacity. And so they have to prove their use and then certain other restrictions. So that's a model that has been developed. So I think basically we can't paint everything here with the same brush because it is still early in the technology and it's not all being used in the same way. Like the way that we use a cryptocurrency in the Bitcoin farming game is so different than the way someone buys Ripple hoping it's going to double in value and sell it, like they buy it on an exchange and sell it. So I think, it's just everything, it's all different and it's going to fall into different buckets. So we don't want to stifle this art innovation. Spousal Genesis was one of the first people that started this off, and they did an ICO. And if they hadn't have been able to do an ICO, then the Rare Pepe model wouldn't have used their model for the cards, and everything kind of builds off each other. So what made Rare Pepe special was any artist could contribute from all over the world, and it actually created quite a way for people in Venezuela to earn income. They were creating these beautiful digital art pieces, and they could make a living off these sales. So, the earth without art is just A. So I think the art is important, and technology, like artists often are, they're on the cutting edge and they kind of push the boundaries of technology a lot of the time. So it's important that we don't cut them off with over-regulation. And then recently, just on September 8th, on Friday, we saw the SEC, Hester Pierce, put out a very, a comment that really models this. They were saying, so all we've seen from the SEC so far was Jay Clayton saying everything's a security, or everything he has seen is a security that was sold in ICO. And then Hester said, when tokens are not being sold as investment contracts, however, they are not securities at all. Tokens are sold for use in a functioning network rather than as investment contracts fall outside the definition of securities. So it doesn't say what that definition is, but they're not in the SEC's jurisdiction anyway, if they're not sold that way. Thank you. Any questions?
Is the reason that, for example, like GBTC, like the Bitcoin Investment Trust, exists and, as you said, is available essentially to hedge funds or other sort of less regulated markets, is that because the CFTC has regulated them?
I believe so, yeah.
So theoretically, if the CFTC said Ethereum, we're going to regulate it, then you could have GETH.
Yes, yeah.
Thank you.
Your last slide had the quote about how if the token is sold for use in a functioning network, it's not a security. What I want to hear you talk about maybe is like this SAFT idea. Is that like, because they're selling those before the functioning network, but it's to fit in this classification of for a functioning network in some weird way, right? What do you think about this SAFT approach?
Yeah, so anyone not familiar with the SAFT, it's the sale of future tokens, and it was created on top of the Y Combinator had created a thing where you could sell future equity. And the crypto community took that and ran with it, and it was basically a way that you could sell the right to future tokens. And I think that always is going to, I don't want to say always, but it's pretty likely going to create a security when you're selling them in the future. It's the functioning network is kind of the way that the crops were sold. The day that you could buy those crops, you could you could create a farm and you could go on and put a farm art on. That would be my understanding of a functioning network at the time of sale. Otherwise, if you sold the crop, you sold the right to buy the crops through a SAFT 3 months earlier, then someone is relying entirely on you to create the website, and you may not do that, but they don't have any control over that. So that's what creates the investment contract, because they're giving you their money and waiting for you to do something that they have no control over the output. Does that explain it? Okay.
Probably a real simple question. So if the CFTC calls it a commodity and the SEC calls it a security, what happens? Like, because it can't be both, if I'm understanding correct.
Right, it can't be both.
Do they step on each other's toes is what I mean? Like, does one cancel out the other? Is there a hierarchy between the two?
Good question, but I think they do have a memorandum of understanding for information sharing with them, and we kind of, all I can go off is what we saw happen with Ethereum. So first the SEC came out and said over the summer, we don't think this is a security because it's sufficiently decentralized. Then several months later, the CFTC puts out a call for input. Is this a commodity? So basically it's in limbo, and I think that's where a lot of the proof of work coins would fall. I don't think any of them are securities, but they're not deemed official commodities either. But they probably, I think over time, all of the ones that were not sold with an ICO will fall under the CFTC bucket. Okay, thank you.